Wi-Fi or office Wi-Fi, wherever everybody's at. Just what we'll do is we'll just pause at that point, and then hopefully you have the ID handy someplace, and just we'll wait to get you back on. And while we're waiting here, the procedure on the first case, because they've only assigned 15 minutes each, there's a cross appeal, as I see. I'll just be lenient with the time on that. So if you can, make sure you cover everything during your initial presentations. And then let's see, the city's the appellant. If you have rebuttal time, just make sure you bring up any arguments that you're going to want to talk about in rebuttal in your initial argument. But I'll give some leeway on that under these circumstances.
Judge Bruns, you're ready to go.
I am ready.
I do have one question.
Sure.
I was going to split my time and use my rebuttal time to answer the cross appeal. Would you rather?
You can do that, because if Ms. Limley raises anything new, which she might on the cross appeal during her argument, you certainly have the right to respond to those. Okay. But what I want to make sure you didn't pull back some of your initial arguments until rebuttal.
Okay, thanks.
Because it is a little different procedure. Well, I think we're ready to officially go now. So I'll officially welcome everyone. Today is Constitution Day, and it's an honor for me to be presiding over this panel of the Kansas Court of Appeals. For those who don't know me, my name is David Bruns. I've been a judge of the Kansas Court of Appeals since 2011, and before that, I was a judge on the Shawnee County District Court. Today, I am serving with the Honorable Sarah Warner, who has been on our court just a little over a year. And for many years prior to that was in private practice in Lawrence. And it's also a privilege to serve today with Senior Judge James Burgess, who for many years was a Sedgwick County District Court judge. I believe he retired in 2013 and has been a senior judge with our court ever since. So probably right around 2014. So that is our panel for today. The first case is Ernatt. I don't know if that's the right pronunciation. Forgive me if it's not. Versus City of Wichita. It's an appeal from the Sedgwick County District Court's decision reversing a municipal administrative hearing officer's finding that Mr. Ernatt's dog is potentially dangerous as set forth in the Wichita City Code. With that, would counsel state their appearances?
Jan Jarman appears for the City of Wichita.
Amy Limley appears for Mr. Ernatt.
And for anyone that might be watching, there is both an appeal and a cross appeal in this case. Each side will have 15 minutes to argue. The court has read prior to today the briefs that have been submitted in this case, any orders that have been submitted as part of the record, and also has received from our research attorneys pre-hearing memos. So we're pretty familiar with the facts. If you would like to reiterate any facts, you certainly have the right to, counsel, but if you want to jump right into your issues, that's fine. I'm going to be a little lenient on the time since there is a cross appeal on this. And then Ms. Jarman, I'd ask you, would you like to reserve some of your time?
I would like to reserve 7 minutes to respond to the cross appeal.
Okay, so my math's not real good, but that's 8 and 7 then, right?
Yeah.
Okay, well, we will proceed then. So Ms. Jarman.
Thank you. May it please the court. I am Jan Jarman. I'm an attorney with the City of Wichita, Kansas. The City of Wichita is asking this court to review the process for an appeal of an administrative determination where there was no record taken at the municipal administrative hearing. This case before you pertains to an administrative determination made by Animal Services, which is a department administered by the Wichita Police Department. That's the structure within the City of Wichita. The facts in the case are pretty simple. You all have reviewed them. I can tell you that this ordinance was passed by the City Council in 2017, and it basically separated criminal charges from administrative decisions. And it asked the Animal Services to create a designation of a dog being either potentially dangerous or dangerous. And that would be made by the Animal Services supervisor. A person could be charged criminally with allowing a bite to occur or run at large or something like that, or no criminal charges could occur, and instead they could just have this administrative determination that their animal is dangerous or potentially dangerous. In this case, I'll say that Mr. Ernatt's dog was declared potentially dangerous, not dangerous. Mr. Ernatt's case followed, this is a pretty new case. It happened not too long after this ordinance was passed, and it followed what the ordinance requires. After receiving a complaint by a complainant, the Animal Services reviewed the facts of the case and determined that Mr. Ernatt's dog was potentially dangerous. This was done pursuant to our ordinance 604045, and it was done ex parte, as the ordinance states. The first level is ex parte. Then Mr. Ernatt was notified by a letter that his dog was deemed potentially dangerous, and pursuant to City Ordinance 6.04.210, it gave him his appeal rights. And his appeal rights are that he can appeal it to the municipal court as an administrative hearing, not as a criminal case. And the judge will hear the administrative hearing, which he did in this case. The judge took evidence from both sides. Mr. Ernatt appeared with an attorney. There was a hearing in this case, and the judge determined to uphold the original determination of Animal Services, and once again deemed the dog to be potentially dangerous. Mr. Ernatt.
Let me interrupt you just a second, just to make sure I understand. I know the city of Topeka, I heard a lot of these types of appeals, not necessarily involving dogs, but involving various things. Sometimes they're sitting as a legislative, administrative type branch, which it sounds like they're doing here, not in a judicial capacity.
True.
Or quasi-judicial.
That's set out in the ordinance.
Okay. And so usually a municipal court is not a court of record, but what I saw often in administrative type cases that came at least out of the city of Topeka is that there was a procedure, at least, where a party could request to have either a recording or to bring in a court reporter, sometimes at their own expense, to make a transcript. Do you have any type of policy or procedure in place that allows for a transcript to be taken of an administrative hearing before the city of Wichita?
We don't provide that. We have no way to record. It's not that we couldn't record. Everyone knows nowadays you could turn on your phone. I think the problem at this point is they don't have a way to store. So the city doesn't. A person who's charged with a crime or in this administrative area can bring in a court reporter anytime they want. That's always allowed. But we don't provide anything. Probably, my guess is for storage reasons, not so much because I could record it with my phone anytime. So in this case,
Counsel, I'm asking or following up with Judge Bruns's question. If that's the case, if the city of Wichita doesn't have any mechanism by which a record is made of these quasi-judicial proceedings, then how is it that any review of that proceeding can occur farther on down the line?
the judge does write some findings of fact. He wrote a page at least, maybe a page and a half of findings on this case, single space. So he wrote quite a lot about the evidence he heard and the determination he made. So there is a record.
But how is it though? So we have a written decision by the municipal judge, but how can an appellate court, whether it's a district court sitting as an appellate court or us, how can we determine whether the municipal judge's decision was supported by substantial competent evidence?
Well, I think that's the heart of this case. I think, first of all, you could look at the record that the judge wrote in this case, and it is sufficient. I think you could review that and determine. But I think you could also call additional witnesses in district court. When it hits district court, I think the district court judge could allow additional witnesses, could allow all witnesses to testify again, could ask for a stipulation of facts. I think there's a whole cadre of things that you could do without having to dismiss the determination completely.
I'm just looking at I'm looking at the ordinance here. I'm looking at 6.04.210 subsection D. And it says the district court will review the case to determine if the municipal court judge's decision was supported by substantial evidence and that the order was neither arbitrary nor capricious. If that's the review that's contemplated by the city in establishing this ordinance, then doesn't the city have to provide some kind of an administrative record by which a judge could do that?
I think what the judge provided in this case as a hearing officer was sufficient to do that.
Now, when I was a district court judge, the appellate courts never thought it was enough just to take my findings of fact as gospel. Substantial confident evidence seems like you need to, they always checked out to see if I was correct or not. If the standard, which is set out by the ordinance, is substantial competent evidence, or here, I think it's a substantial evidence instead, but it's the same thing. Going back to Judge Warner's question, how can this court or the district court know whether the administrative hearing officer was correct and did have sufficient evidence to make those findings without at least some type of record?
Well, I think that's true in a lot of appeals. You don't get to, well, sorry, not you, but the district court doesn't get to reevaluate the witnesses at all. Instead, what the hearing officer in this case wrote, that he heard this witness, and they said these things, and that led him to this decision. The district court is only supposed to determine whether those things he heard could have led him to that decision.
So what if he made a mistake? I mean, we're all human beings. I'm sure I made a few mistakes, and I always hope that somebody filed a motion to reconsider instead of an appeal, because if I just made a mistake, I could correct it. The reviewing court without some type of record has no ability to know whether a mistake's been made or anything like that. I realize you can call additional witnesses, and you could have gotten together, and it would have been nice in a perfect world if you would have gotten together and recreated some type of a record to review, which is done at our court a lot. But I guess the trouble I'm having with is not that it's impossible to review, but it makes it very, very difficult to review without knowing what the underlying evidence was to determine whether those findings of facts were supported by competent evidence.
Except in your world, you're asking the judge in district court to determine whether the facts were true or not. And that is not what an appeal.
No, I'm saying to determine whether there were sufficient facts to support those findings. And how do we know that? If not, we're just a rubber stamp of the findings of fact.
Because you would look at the writings. There is a record in this case, and the record is the hearing officer's findings. And I think an appellate court could look at those findings and determine whether or not, based on the facts that he said he believed, whether the conclusion was arbitrary or capricious, which is the only thing an appellate court should be looking at, district court, I mean.
Well, the ordinance also says that we look to see whether that decision is supported by substantial evidence, right? So that means that we have to be able to have some kind of a factual record by which we can determine, or from which we can determine, whether those findings that the district court set, or that the municipal court set forward in this case, were actually accurate based on the record that was presented, right?
No, I disagree. I don't think you determine whether they're accurate. You determine whether his findings of fact make sense with his conclusion. I don't think the district court gets to go back and determine whether or not they found a witness credible or not. That is not appropriate in an administrative hearing. That decision has been made by the hearing officer.
But what if, for example, and I'm not saying that this happened in this case, but hypothetically speaking, what if a municipal court judge makes a finding that a dog bites a person's elbow, and actually the dog didn't bite the person's elbow, the dog growled at the person, and the person snatched the elbow back, and that was the testimony that was provided. In the universe that we have here, with just the municipal court's decision, a district court judge, an appellate court judge would have no way to determine that inaccuracy, right? So that finding would not have been supported by the record, but we would have had no way to determine that.
I'm not sure you would in any administrative decision, because you're not retrying the facts. And it sounds to me, in your question, you want to retry the facts, and that's not what should be happening at district court. It should only be determined whether the judge's finding of fact makes sense with the finding, with the determination.
And if
And
that finding of fact is supported by the record.
I don't think so. I disagree with that. I think that the judge gets to outline what their finding of fact was. If the district court has a question about it, they could have the witness testify for them, I suppose. And that's my argument in the brief, which is there's a whole list of things you could do without just outright dismissing this. But I guess my understanding or my belief is that you don't get the district court doesn't get to retry the facts. You're stuck with what the judge thinks. Then you have to determine whether that makes sense, whether it was arbitrary or capricious. I see your point. It's whether it was arbitrary or capricious, but I think there's enough in the writing.
Based on your argument, then, whatever the judge finds is supported by substantial evidence. We don't get to review that.
You could determine whether the judge wrote enough to make you feel comfortable. You can review it though by calling additional witnesses, by asking for stipulated facts, which is what seems to happen in a lot of these cases. There are a lot of other ways. I understand if the court wants to hear more, and I think that's proper. I think in Frick you can. The judge could call more people, but the one thing the judge can't do is just outright dismiss it.
Okay, let's, you're over your initial time, but I'll be lenient on this. Let's move on a little bit then. There are options, no doubt. I think we would all, everybody on involved in this conference would agree that there are options out there. But does a district judge that's reviewing have a duty to say, okay, you two get together and stipulate to a transcript? Or is that just an option of something that you can do as professionals? Does a district court have any duty to do that? Or is
No.
that incumbent upon the attorneys or the parties to do?
I don't think the district court could force stipulated facts. Absolutely agree. It's one thing if the parties could agree, that'd be great.
And then the same with additional evidence. I don't think it's the district court's role to say what additional evidence you want to put on. It seems like it's incumbent upon counsel or the parties to come forward and say, hey, we would like to present some additional evidence. Is that accurate, or would you?
Well, I actually think that the court could be more aggressive in what they want to hear.
Right, could be, and they could, and I can tell you, I've done that before as a district judge. I one time asked the parties if they would get a court reporter and preserve a record, and they agreed to do that. Certainly the judge could ask, but what I'm trying to find out, does the judge have a duty to do those things? Because we're worried more about the duties. If it's discretionary, then we'll leave it to them.
My argument is the judge has a duty to do something. It could be any one of many things. And I think the judge, she would be allowed to ask for additional witnesses, but it would be, I think they have the opportunity to do that. It's probably not a duty.
Okay, well, why don't you wrap up your first section here, and then we'll have Ms. Lemley go, and then we'll come back to you.
Well, actually, you all got right to it. So I don't need to finish up any idea. You see my point. We've argued my point. I think there were a lot of different options that could have happened. I think dismissing this whole case was not one of the options that was allowed.
Let me ask you one more question then on that, and that is the statute's a little strange, as we probably all know, in that it gives certain things that a district court can do. One of them that is not mentioned is remand. Does the district court have the authority to remand to the municipal court for an administrative hearing or for additional record?
Doesn't say it can't. Would be my best argument is it doesn't say it can't.
Well, I understand it's a little strange, because I think there are cases in which that happens. There are remands in real life, but the statute doesn't say it, so I thought I'd better ask you. So with that, why don't we go to Ms. Lemley on her argument, and then we'll come back to you. Ms. Lemley?
Yes, and I'd like to reserve half my time for rebuttal on the cross appeal issues, if I might, Your Honor.
Well, since we're doing 15 minutes,
it doesn't make any difference.
yeah, why don't we see how much we have, but I'll give you a few minutes if you think you need to respond to something that Ms. Jarman says on the cross appeal.
Fair enough. I want to get right to the questions the court's asked. You asked about, because there was no mechanism, Judge Warner did, because there's no mechanism for a record to be made. How can any review occur, any review under this substantial competent evidence review occur down the line? That is the key to this case, but I want to go one layer deeper when I call the deficiencies of this ordinance to the court's attention. Because what happened was that the police officer, Lieutenant Sigmund, made the finding of potentially dangerous dog based on an entirely subjective approach to any facts, without hearing from Mr. Ernatt, without the bottom of the fence being measured, without knowing that the dog's head, it was physically impossible for the dog's head to fit under the fence, and without there being any evidence of a bite. So that determination was made by Lieutenant Sigmund the very day after the complaint was made, or the investigation was done. It was done on Monday, and the officer came out on Sunday and couldn't find evidence of the bite at that time. So then the next thing that happened was we come in and we appeal. The appeal that we get from the original fact finding by Lieutenant Sigmund is not a de novo appeal. It's, if you look at what the municipal judge is supposed to do when he gets the case in front of him, he applies a substantial competent evidence standard to what the police officer's done. So here we are with a subjective, ad hoc evaluation of the facts without Mr. Ernatt having any opportunity to be heard, without having any foundational basis for the potential dangerous dog decision other than what Lieutenant Sigmund chooses to believe or not believe. And now we have the municipal court judge under his part of the ordinance making a finding about whether or not there is substantial evidence to support Lieutenant Sigmund. This is all one-sided. This is not due process. Then when we appeal to the district court, the city takes a position that we don't get a trial de novo. Nobody at this point has applied either a burden of proof, either by preponderance of evidence or beyond a reasonable doubt, although there are criminal penalties throughout this chapter. And no one has given Mr. Ernatt the process of even having his story considered under any other review standard other than, was there substantial competent evidence to support Lieutenant Sigmund?
Let me stop you just a second and ask a question before we get to the district court. It seems to me from reading, I've got the ordinance in front of me, it seems like it's inconsistent on what the role at the first level is, because subparagraph A says it shall be a de novo quasi-judicial proceeding, and then paragraph B says will be reviewed under a substantial, compelling, or again, I don't recall if it's substantial, compelling. I think it just may say substantial evidence. No, it is substantial, competent evidence standard. So it seems to me like those two conflict.
Exactly, Your Honor, exactly. And if you look at then Judge Zarnow's order, he doesn't say that anybody met their burden of proof. He doesn't even have any facts that Mr. Ernatt put in his order. They're all one-sided. They're only the facts that Lieutenant Sigmund could have relied on. He didn't put in there the evidence that we put in about the fence not having gap at the bottom big enough for the dog to put her head through. I mean, that's just basic due process, Your Honor. And I don't know how Judge Gehring can be expected when he gets this in his lap to go back and evaluate this, because at no point has anybody applied either a reasonable person standard or a preponderance of the evidence standard to whether or not the city proved its case. This left Mr. Ernatt without any due process. I think the city's, and this is before we get into the cross appeal arguments about whether or not the 6 criteria for determining dangerous dog and dangerous dog or potentially dangerous dog or anything other than vague. I argued that they are, but frankly, you don't have to decide the constitutionality on the issue of vagueness. And I know courts, I'm cognizant of the fact that courts do not like to decide constitutionality issues if they don't have to.
Well, we're supposed to presume that things are constitutional.
Well, I really wish you would find this vague, but I know that you don't have to in this appeal. But I think that you are confronted with a due process issue that is squarely before you that must be decided. And I think even though Judge Gehring didn't articulate it that way, that's what he was looking at, was a due process problem. Under this appellate procedure, under these stages, Sigmund, municipal court, Judge Gehring, there's no due process anywhere along the way that would permit him, as the questions the court's been asking, to apply either an arbitrary and capricious review or the power review to determine whether it was arbitrary and capricious, or to determine whether or not there was substantial competent evidence in this whole process. So I would like for you to find that this is vague. I briefed it, you've read it. I'll preserve that in case we get into any cross appeal arguments. But whether you reach that issue or not, I think, Judge, that I think the court needs to find that the due process that was given does not permit Judge Gehring to do anything other than dismiss this case, which is what he did. He found it in our favor and dismissed it. And I don't think the solution is to go back and give the city a do-over whenever the process has been so flawed from the beginning. That doesn't seem like due process to me either. We're now 2 years out from this, and you know, my client's very worried about this situation, as anybody would be. I can tell from your questions that you know what the issues are, and I don't want to repeat everything in the brief. I do have a little bit of cleanup. In my reply brief, I overstated something, which I'm ashamed of. I want to call to your attention. I cited the Davenport case, and I think that is a very important case. Davenport Pastures versus Morris County Board of Commissioners. And in the discussion of the case, I mentioned or said that the standard was appearance of conflict, if there was a reasonable appearance of conflict, and that's not the standard. There has to be a probability of a conflict. So I overstated that, and I caught it when I went back and read those. I don't think it affects your decision.
Well, we appreciate you being candid with us. Thank you.
But that case is important because it is a due process case, and it talks about at length about what due process anybody in the system in Kansas is entitled to. And that there is no way you can fit this case into a due process model that satisfies Kansas Bill of Rights or the 14th Amendment. And the city does have a conflict. Before we could even get up to judge a financial conflict, not only did Mr. Ernatt have to buy his signs from the city, pay the $50 fee, and pay a non-refundable $200 fee before he could even appeal to municipal court. The fee for $50 for the potentially dangerous dog license is for the life of the dog. And he is subject in the future to criminal prosecution for a wide variety of things that are set out in the statute or in the ordinance. And there is no distinction in this ordinance between the criminal aspect of it, the misdemeanors, and the administrative aspect of it. It's all blended in together, and there's not a clear-cut separate procedure for the two parts of it. And there are no administrative regulations to be applied. There just aren't any. There's only the ordinance under which you can be either criminally or administratively subject. Do you have any questions for me? because I'm about to run out of my thoughts.
Well, let me ask this. You heard our questions about what obligation a district court has. Did the district court deny anyone the opportunity or request to present additional evidence in this case? Did anybody request that, and was it denied?
I asked for a trial de novo, full evidence, and Ms. Jarman stipulated that I could have that. But then when we got further down the road, her view of what that would look like was not de novo. She said, she argued to the judge, and it's in volume 3 of the transcript, that the de novo trial that she had agreed to would only allow the judge to apply substantial competent evidence standard, and that he could not put anything in, that we could not put anything in evidence that wasn't reflected from the municipal court's order. So the city wanted us to be restricted to that. And of course, with no record, there was not even any real agreement about what we ought to be restricted to, because as I said, from our perspective, the municipal court didn't put our facts in, it only put in one side of the facts. So that was we were never gonna get along on that. And the judge was just in a place where if he couldn't do that. You can't apply that standard of review, which is a differential standard of review, to the situation he found himself in, period.
Was there anything else then you'd want to add on the cross appeal at this point?
I'm going to rely on the briefs for that with my one correction. I think we've briefed the applicable law, and I don't need to repeat it to you guys.
Any other questions from the panel? If not, we'll go back to Ms. Jarman, and I'm trying to be lenient on this, so how about we just go 5 minutes, and then if you need a little more, fine, but if not, you probably can get it in there.
I think I can be brief. Thank you. On the cross appeal as to it being unconstitutional, I think my argument is obvious in the brief, which is I have never seen such a specific set of ordinances all the way down to the depth of the bite. I think any reasonable person, any person of reasonable intelligence could look at that ordinance and know what it means, because it takes away probably a lot of the questions, but it does leave totality of circumstances. The judge can look at the totality of circumstances, or the hearing officer, to determine. I think the biggest question you all seem to be focusing on, and I understand that, is that of due process. I want to clarify one issue. Under 604-210, the A section does not apply in this case. It's B. It's going to be B because it's specific to dangerous dogs, and D applies to A, B, and C. So when we talked about, well, A says it's quasi-judicial, really A shouldn't be read into this in my argument. One of the biggest.
So let's make sure we understand that. So A, you're saying, is just after there's already been a determination.
A is for
what is A applicable to then?
If you're denied an animal maintenance permit, if you're denied, there's a lot of different administrative decisions that the animal services makes, and A applies to those. So
anything but a dangerous or potentially dangerous dog is what you're saying.
Right, because it says unless otherwise specified, and then B specified.
So they would be entitled to de novo trial, but in these cases, it's only entitled to a review of substantial competent evidence.
Right, and here's why. They have it's a different appeal process because there's so many dangerous dog appeals versus animal maintenance appeals. An animal maintenance permit appeal would go to the city council. The city council could not possibly hear all the dangerous dog determinations. So they made a separate section for dangerous dog where it goes to an administrative hearing officer instead of the city council for the purpose of expediency. That's why it's different.
If it's not going to the city council, though, if it's not going to the city council, that burden's removed. Why is it Why isn't it a de novo hearing?
I don't know, because there is an actual hearing with witnesses and cross-examination at the administrative hearing level with the judge at the appeal level. You get the same benefit, it's just a different fact finder. So
What's the quantum of proof there? What do those potentially dangerous dog ordinance provisions? How do you prove those? By preponderance? Do you prove them by clear and convincing evidence? Since there's a fine, is it by beyond a reasonable doubt? What are we talking about?
well, there's no fine. So that's one of the big questions here that Mr. Ernatt never understood, which is there's criminal sections where you can go, it's A and B misdemeanors. You can go to jail for it, you can be fined for it, you have a right to a public defender for it. That's one section. 604045 is not criminal at all. It's a licensing ordinance, whether or not they're going to make you license your dog as a dangerous dog. And then it has requirements to keep a dangerous dog. It is all administrative. Now, if you violate it, like a liquor license, that's administrative. We give liquor licenses, but if you don't get one, you can be prosecuted. Or if you don't comply with all of the rules of having a liquor license, you can be prosecuted. That does not make the liquor license itself criminal. It's an administrative. Same way with dangerous dog determinations. They are administrative in nature. They carry no fine. They carry a licensing fee, but it's just a higher licensing fee. For Mr. Ernatt, it's a $50 fee a year instead of a $10 fee.
So what does the city have to prove that he is necessarily subject to that licensing provision? What's the standard of proof there that the city has to meet?
That's under 604045, and it's the animal service supervisor can declare it. It does not give the level of proof. I would argue it's clear and convincing, but it's the animal services coordinator who makes the determination. Everything else is an appeal of that determination.
So there really isn't a trial de novo any place then, because
Well,
you
there
got
is-
the supervisor making the decision, and then that's being reviewed under substantial competent evidence. Then the district court's doing it under substantial competent evidence. Then I suppose even we are doing it under substantial competent evidence. So where's the trial at all?
Well, the trial, I agree that the standard for the administrative hearing officer is to determine whether there was substantial competent evidence to make the finding in the first place. But don't misunderstand, there is a hearing of facts with cross-examination. It was argued that they didn't get to tell their side of the story, but you know from Judge Zarchin's opinion, which was submitted, first, Officer Baker looked under the fence and did observe a gap. It said that Mr. Ernatt put on 2 witnesses who testified about what they have seen in the dog. They've not seen any aggressive action. They never observed Tess at his own environment and never seen the fence. Mr. Ernatt testified that Tess has never shown aggression. There was evidence provided and there was cross-examination. So I understand if the issue is going to be what's the standard, but there is due process. There was a trial. And it was sufficiently written down that a district court judge could look at the evidence presented and determine whether that was a fair conclusion, which is all the appeal for an administrative determination should do.
Let me move to a different issue, and hopefully that's about all we need to take up on that part of it. But turning over to and I don't know if we'll reach it or not, but if we did reach the overbreath, under the definition of a potentially dangerous dog under 6.04.045B1, if I'm reading that correctly, any dog is potentially dangerous because even puppy could nip, scratch, or cause an abrasion. And bless you, Judge Burgess.
Thank you.
Why wouldn't any dog be potentially dangerous under that definition? That every puppy even nips, scratches, and or causes abrasions. Every
He
cat
does.
does. Every kitty does. Probably any pet you have other than a goldfish.
One moment, because there's a section in here that gives the judge the ability to consider mitigating factors like play or that the dog was defending a person. The judge, it's not just the minor bite or nip. Let's see.
Because the definition seems pretty darn broad, but you're saying there's someplace else that limits it.
Yes. Yes. Oh, you go back up. So the judge is also supposed to look under A. So the administrative hearing officer, in this case, Judge Sargent, views under A, in determining whether the dog is deemed dangerous, a fact finder may consider potentially mitigating circumstances, whether the bite or scratch was made in a playful manner without any sign of aggression, or whether it was a response to pain, abuse, criminal trespass, or intentional provocation. So.
Okay. Any other questions from the panel? If not, Ms. Limley, is there any rebuttal you'd like to give limited to what you've just heard?
No, I don't think so, Your Honor.
Okay, any other questions from the panel? Well, this case will be deemed submitted, and I think you both know, but we try to get our opinions out within 60 days of the oral arguments. We appreciate your arguments here today, and we thank you both.
Thank
So
you.
we will be in recess until the next case. I'm just going to stay on, and somebody will tell me what to do. Thank you both.